I'm Jennifer Giesbert from the Area Agency on Aging, and I'm here again to have a discussion about some issues that affect our seniors. I'm going to let the panel introduce themselves today. We have
My name's Alan Wasserman. I'm an attorney with Idaho Legal Aid Services in our Coeur d'Alene office, which serves the 5 northern counties.
I'm Paul Graves from Elder Advocates.
I'm Jan Young. I'm the Ombudsman at Area Agency on Aging.
So our topic today is going to be around seniors or vulnerable adults who can no longer make decisions on their own behalf and what happens to them. We're going to talk about a few scenarios, but will you start, Alan, by defining for us what guardianship is?
Okay. Guardianship is a creature of law that's legislatures set up a process whereby an individual can gain control over another individual who has lost the capacity to make decisions for themselves. And so it's an entire court process because it's such a significant imposition on a person's individual liberties that we have an elaborate court process that has to be followed, and only a judge can ultimately impose a guardianship on somebody.
Okay, and then so that's when someone cannot make decisions on their own behalf, and
Right.
that must be at a very significant level, that things have to decline for those around this person to think that.
Right, and the law talks in terms of a person losing the ability to make responsible decisions for themselves or losing the ability to communicate.
Okay. So the responsibility word came up, and that, I think, in the community poses a little bit of a difficulty because people look at self-neglect issues or care issues, and sometimes they say, oh, that's not responsible. We need to get a guardian. What have you seen, Paul, that looks like someone not being responsible that you believe was actually a guardian, that they needed a guardian? What did that, do you remember anything?
I recently was a court visitor for a person or in a guardianship case where where it appeared as though the person that we assumed needed guardianship was being cared for by another person significant in their lives, and yet there was a great deal of neglect going on. It was hard to determine whether the neglect was self-imposed or imposed by the caregiver or a combination of both. When I met this person, in a nursing home after admission there, and there were times when I found myself saying privately, this person really does need guardianship because of the inability to make clear decisions.
Right.
I was like, the person moved in and out of awareness in terms of what was going on
Right.
in the relationship with the caregiver as well as health care.
Right.
Or the health issues.
Right.
And as it turned out, not too long, in fact, just a few days after I had submitted a court visitor report, this person died of an issue that had not been occurring when first admitted to the nursing home.
Oh, so that was very unfortunate that came up at that time. But that was not related to the issues that were driving the guardianship. That was
at least not directly.
that you knew of.
Right.
Okay.
Right.
Okay. So Jan, you see people in facility, and sometimes that's our first contact, but sometimes our first contact is in the home. Tell us about what you see in terms of what people perceive to be the authority to make decisions for people that are in facility.
Well, a lot of times when a person is in a facility, they've given someone in their family power of attorney. And power of attorney does not have the right to make the same decisions for that person as a guardian does. And they'll go into the facility and they'll say, well, you know, so-and-so can't come and visit, and I don't want him going out any place or her going out any place, and I want you to, you know, set limits on them. And then the resident will usually complain to me, and then I'll sit and I'll try and educate the resident as well as the family member that power of attorney is not the same thing as guardianship. And what my role as an ombudsman is I'm supposed to advocate for what the resident wants.
Right.
Sometimes it's not always what's best for the resident, and I tell them what the consequences might be, but I'm supposed to be the residents on the resident side.
Yes.
So a lot of times I talk about the consequences of their choices and just, you know, intercept when they're making rules that they really don't have any right to be making.
Right, and we hear that rub against around power of attorney, power of attorney for medical or financial, and the misconception that that's the same as guardianship. So can you explain to us what that's about?
Well, one thing that I like to tell people is that when there's a power of attorney in place, you have voluntarily given it to somebody.
Right.
You have the right to take it away if you wish. And if there's ever a disagreement between yourself and the person you gave the power of attorney to, you win the argument. You are still in control of your affairs.
Okay.
The only reason that you've given them the power of attorney is a matter of convenience. If it's just inconvenient for you to sign documents, they're in place to sign for you.
Right.
And of course, a durable power of attorney does continue in effect even after a person becomes incapacitated. But again, as Jan pointed out, it doesn't give the person who holds the power of attorney, often called the agent or attorney in fact, any decision-making authority over the individual.
It's a convenience.
Right, it's a tool that I can use in advance to authorize you to sign things for me if it ever becomes inconvenient for me to do so.
Right. Now, what do we and the public need to be aware of in terms of at what point, what kinds of things do we need to look for, and at what point to say, whoa, don't have that person sign something? What would you expect?
Well, if you're talking about when does a person lose the capacity to give,
Yes.
knowingly give a power of attorney or to sign other documents, and that's always a tough question if it's no hard and fast rules. In my view, a lot depends on the complexity of the document the person is being asked to sign. If someone's being asked to sign an elaborate trust or a complicated will, well, that takes quite a bit of understanding and thinking through, and it could easily be that someone's lost the capacity to do that, while at the same time maintain the capacity to understand the very simple concept of, yes, daughter, I trust you to sign documents for me when I'm not able to.
Right.
And in that case, I would say a person could be incapacitated or incompetent to sign a complicated document, but a simple power of attorney to a daughter or an adult child, to what you might consider a natural or obvious choice
Right.
to do that.
So signing over the ability for a daughter to pay the bills on time is different than the daughter bringing in maybe a deed to land or property and having the individual sign that when there is a possible question. Jan, did you?
I recently just had a case to where I had a lady who was in a skilled nursing facility, and her son and daughter-in-law had power of attorney for her, and they were wanting her to leave the facility and go live with them at home, and she really didn't want to do that. And so then we all had a meeting, and the family on one hand was saying, well, she's not competent, she's been, dementia for 12 years. But yet on the other hand, the night before, they had brought in a new will, new power of attorney documents, and documents pertaining to her home.
Oh, yes.
And her property. And I said, you're telling me that she can't make up her choice, she can't make decisions for herself, yet you just had her sign these documents. I said, that's a problem, and I run into that a lot.
So Ellen, I'm sure that a lot of people come to you and say, what should we do? How should we handle this? What's your advice to families?
Well, the first thing to say is every case, every situation is unique. So there's no just pat advice to share with someone. You just need to take into account the particular needs of that situation and the particular capacity of that person to understand. And you also have to make some judgments about, how much are they being asked to authorize? Getting back to, is it something involved? Is it giving away all their assets? Or is it simply authorizing someone with a power of attorney to sign documents for them with the understanding that that person, that agent, is still responsible, is still accountable to the principal who signed it. But then you also have to deal with the issue of, is the person no longer able to understand? And then you have to explore whether you need to pursue a guardianship over that person.
Ellen, let me get back to the word inconvenient. When you used that, I was a little surprised because I've not heard it used in relationship to a durable power of attorney for either health care. And my mind immediately went to inconvenience of time or inconvenience of location. Is there more to that? Because I'm thinking in terms of capacity to make those decisions.
Well, once the power of attorney is in place, a durable power of attorney, then yes, it can be inconvenient because of the loss of capacity from the principal. Yes, then they can no longer sign, but the power of attorney has been in place, and so the agent can sign for them. But it also can apply to just time and place. It's just inconvenient. I mean, powers of attorney are very powerful tools. I can say, I just sold my house, but the closing is next week. I'm going to be out of town, so I have this special power of attorney that authorizes you to sign the deed at that closing. But typically, we use a general power of attorney so the agent can deal with any situation that comes up. But it really, in my mind, it comes down to, can I no longer do it? I've authorized you to do it. But even if I can still do it, I've authorized you to do it if it's inconvenient for me. It doesn't mean I can't anymore, it just means it's inconvenient. But I want to draw a distinction with the healthcare power of attorney. Because a healthcare power of attorney whereby you authorize someone to make healthcare decisions for you only goes into effect when I can no longer communicate. So that's a difference. It's not a matter of convenience.
And my context is predominantly within the healthcare realm, and so I'm thinking in terms of capacity to make the decision.
And that's right on the language of that durable power of attorney for healthcare talks about it's not effective until the person is no longer able to communicate.
So if they are unconscious and they have gangrene and their leg needs to be amputated or they will die, and they're unconscious, that would be an appropriate time for a person that has power of attorney for healthcare to step in and say, yes, please go ahead.
Yes, that would be a very straightforward situation.
Okay.
But it's also, on the flip side though, is if that person is not incapacitated, the fact that they've given you a power of attorney for healthcare doesn't give you any authority over their
cognizant to
exactly.
say what they want.
Right,
Okay.
And I've run into that in a lot of facilities to where the family member starts making the decision that, no, we're not going to seek medical attention, or no, you know, they have pneumonia and we don't want
To
them
treat
to
it.
have any antibiotics. And the resident is sitting there saying, no, I want to. And they say, well, you gave me permission. And then I come in and I say, no, you know, that permission doesn't override what they want right now.
Right.
It's when they're unable to make their wishes known.
Right.
I was in a conversation that just this morning with an adult child, and this is a nuance of, I think, of what we're talking about. And his father is in a nursing home, his mother, and they have relocated to this area. Father's in a nursing home, the mother is in an apartment. And he struggled some because it felt as though he was, in a lot of ways, he was becoming the parent. And because he was having to make some decisions, especially on his father's behalf. And I tried to help him understand the distinction between the roles may be reversed, but the relationship isn't. You're still the son. And to honor that relationship, even while you're having to maybe make decisions you're not comfortable in making.
Right.
It complicates it, but I think for me, it also clarifies that there's a respect to be given.
I think that's very important, and I think that's a really important note to end on for today's discussion, is that I think that the adult still wants to be respected, and I think that the kids still want to feel that they can respect that parent, even though the roles get reversed. And so for us to confirm that and to advocate for that is really important. And then from the legal standpoint, encourage them to.
Yes, I think that's true. I think these legal frameworks we've set up are just something to fall back on when people can't just work things out as a family unit, for example. And having these powers of attorney or guardianship doesn't prevent people from discussing and coming to reasonable decisions as based on their history and family dynamics. It's all, we have to just fall back on the who really has the authority when we can't reach a reasonable decision amongst ourselves.
Yes. Yes. Well, thank you to all of you. I think we're going to have to go a little further with this discussion.